I would like to start this presentation highlighting two statements and one recommendation made in August 2010 by 76 law professors from universities around the world that include universities from Canada, Singapore, United Kingdom, Australia, United States, China, South Africa, Russia, Germany, among others. The statement includes as general principles that foreign investment may have harmful as well as beneficial impact on society, and it is the responsibility of any government to encourage the beneficial while limiting the harmful, as well as states have a fundamental right to regulate on behalf of the public welfare, and this right must not be subordinated to the interests of investors, where the right to regulate is exercised in good faith and for a legitimate purpose. Two of the recommendations of that academic statement argues that civil society, and I will add sovereign governments, should continue to take steps to inform its constituents and society at large of the failures of and threats posed by the international investment regime, and to oppose the application of that regime to governments that undertake legislative or general policy measures for legitimate purposes. And the second and most important recommendation says states should review their investment treaties with a view to withdrawing from or renegotiating them. In light of the concern expressed by several governments and civil society, they should take steps to replace or curtail the use of investment treaty arbitration and should strengthen their domestic justice system for the benefit of all citizens and community, including investors. And the reason I decided to start the presentation with these academic statements and recommendations is because Ecuador implemented them many years before the academic public statement was made public. But as the Ambassador Celi said this morning, Ecuador did not arrive at this conclusion easily. The path to get to where we are today was long, litigious, and costly on many levels. For decades, transnational corporations took advantage of our country's institutional weakness as related to the public sector, and of the lack of international obligations for corporations to comply with human and environmental rights, and deep external technological dependence by developing countries on foreign companies who abuse the trust afforded to them. Irresponsible extraction of natural resources, inadequate methods of remediation, and lack of financial compensation for victims of corporate responsibility harm not only the human life, but also the environment. Arguably, the most egregious example is that of Texaco Chevron, almost 25 years operation in Ecuador. This relationship with Texaco provided many lessons for Ecuador and the world in a number of different fields, particularly on human rights, investment treaties, international relations, business ethics, international law, and international arbitration. Now, for a matter of time, I will try to briefly present the Chevron case. Between 1990 and 2006, Ecuador signed 26 investment treaties. In 2008, Ecuador approved a new constitution, becoming the first national constitution in the world to enshrine the rights of nature. However, the same constitution, in its Article 419, states that the ratification or denunciation of international treaties will require the prior approval of the National Assembly in several cases. One of the cases is when bilateral investment treaties attribute competences of the domestic legal order to an international or supranational institution. The approval of the Constitution automatically requires the withdrawal of investment treaties. On September 23, 2009, 17 months before the Ecuadorian courts reached any final judgment in the Chevron Lago Agrio litigation, Ecuador was notified of a third arbitration proceeding before the Permanent Court of Arbitration at The Hague, requested by Chevron. On 2010, the Constitutional Court of Ecuador declared 3 articles of the Ecuador-United States Bilateral Investment Treaty unconstitutional. Up to 2013, Ecuador has been involved in 36 international arbitrations, and CATISA, a special commission appointed for auditing the bilateral investment treaties and matters of the international system of arbitration, started to work. Out of the 26 bilateral investment treaties signed by Ecuador, 21 have been already denounced. 9 of the investment treaties have already finished the process of withdrawing. Up to 2014, Ecuador has 16 active cases of arbitration, 6 being with oil companies and 3 with mining companies. The litigation with Chevron and Occidental are the most important ones for Ecuador. Ecuador also has 5 notifications on controversy in process. 2 notifications are from oil companies. One of the most, if not the most controversial cases on investor state litigation is the Texaco Chevron case. The allegation of Chevron against the Republic of Ecuador are that Ecuador breached the bilateral investment treaty with the United States, that Ecuador and Petroecuador are exclusively responsible for the sentence in the judgment of Lago Agrio, that Chevron has no responsibility for the environmental damage in the Amazon after its operations in Ecuador, that Ecuador must hold unaccountable to Chevron in relation to the trial of Lago Agrio, and finally, compensation for moral damage. The Republic of Ecuador's arguments include that Ecuador has not breached the bilateral investment treaty with the United States, that the dispute between Chevron and Texaco and the community in Lago Agrio is a trial in which the state is not a part, and that in the release agreements between Ecuador and Texaco does not exist any obligation by Ecuador to maintain, indemnify, protected to Texaco, or that Ecuador has to defend Texaco against claims by third parties. The problem that we have in international arbitration is the fact that bilateral investment treaties commit states to lofty words and phrases without any discretion as to what those phrases actually mean. Ecuador sustained that the extensive tribunal interpretation of the United States-Ecuador bid has many errors in the interim award as well as in the partial award. Texaco left Ecuador in June of 1992. The treaty entered into force 5 years later in 1997. The treaty expressly provides that its terms apply only to investment disputes existing as of or arising after the day the treaty entered into force. The treaty's non-retroactivity provision reflects the fact that the state entered into the treaty to encourage future investment, not to grant rights to those who are already doing nothing for its economy. By exercising jurisdiction at all in this dispute, the tribunal dashed the state's contractual expectation. This was not what Ecuador had bargained for in 1997. The tribunal granted an interim award instructing the state, including its courts, to take all necessary measures to prevent the enforcement of the judgment issued by its courts in favor of the indigenous plaintiffs. State judiciary is perhaps the paramount symbol of sovereignty. The tribunal not only reached the conclusion that it has jurisdiction over the dispute, but it had the authority and power to order the domestic courts of a sovereign state to suspend enforcement of one of its judgments. It reached this conclusion notwithstanding that, first, the indigenous plaintiffs brought this action 20 years ago. Second, the court found that the pollution for which the defendant has been held responsible continues to cause the indigenous plaintiffs harm, threatening their lives, and third, complies with the entering a war will violate Ecuador's commitment under various human rights conventions. The tribunal more recently determined that the 1995 settlement agreement among the Republic, its state-owned company, and Chevron prohibits the plaintiffs from obtaining any remedy pursuant to a provision under the Ecuadorian Constitution guaranteeing the citizenry the right for a clean environment. The tribunal reached these conclusions on the basis that enforcement of such constitutional provision is a right belonging to the state, and then the state released such claims as part of the 1995 agreement. The state is surely a part to the settlement agreement, and is just as plainly cannot sue on claims that it released. The indigenous plaintiffs, however, are neither a party to the treaty nor to the settlement agreement, and just as plainly could not have released any claim against Chevron. In ruling as it did, the tribunal ignores the fact that under Ecuadorian law, the government cannot settle claims on behalf of the citizens. No party has the power under Ecuadorian law to settle any other power's claims, most especially when the rights at issue are fundamental rights granted by the Constitution. It will take 3 more minutes. Criticism of the state investor dispute system is rapidly increasing. The criticism is largely due to investors who often abuse these arbitration systems, either asserting that governments violated the bids because public policies had threatened their revenues, or by claiming that they were unfairly or unequitable treated when due process did not find in their favor. More and more, the international community and the academic world realizes that this broken arbitration system weakens the sovereignty rights of countries to conceive and implement public policies aimed at improving health, the environment, protecting human rights, and other social protections for their citizens. Recommendations including a most transparent selection of the arbitrators, the establishment of appeal instances, or exhausting local remedies before arbitration are more and more common among states and academics. Just from the lessons learned by Ecuador, not only the Republic of Ecuador, but also the developing economics and the academic community have made several recommendations that could better off the system. International organizations should refrain from promoting investment treaties and should conduct research and make recommendations on the serious risk posed to governments by investment treaty arbitrations, on preferred alternatives to investment treaty arbitration, including private risk insurance and contract-based arbitration, and on strategies for states to pursue withdrawal from or renegotiating on their investment treaties. The international community, members large and small, must change the ways that corporate social responsibilities measure. It must value human rights no less than it values profits. After all, the Amazon indigenous people started to fight for justice only a few months after Texaco finished its almost 25 years old operation. And they are still fighting, while polluters and its lawyers seems to be celebrating. Thank you.